Welcome, everybody. We're going to give everyone just a minute to sign on and get settled, and we'll get started in just a minute. But thank you so much for being here. Welcome, everyone. Thank you so much for being here. I'm absolutely thrilled to have this training today on helping survivors successfully apply for SSI and SSDI with Maddie Sandoval. We're going to go ahead and get started. We may have a few people trickle in, but I want to make sure we have plenty of time to hear from our speaker, so we'll go ahead and kick it off. My name is Jamie Beck, and I'm the President and Managing Attorney of Free to Thrive. And the genesis of this training came from us at Free to Thrive really struggling with how do we support our clients who are applying for SSI and SSDI, and how do we ensure that they are successful in those applications. And really the goal of this training is to help our survivors not need the help of a lawyer. The goal is that they successfully apply and don't need to file an appeal. If they do get to the point of needing a lawyer, that's where lawyers like Maddie and others that do this really highly specialized work come in to help survivors and others with this process. But really the goal here is to set up survivors for success. So we're thrilled to have you, and really looking forward to hearing from Maddie. Just a few quick housekeeping items. We do have the Q&A function open. If you have questions, you don't need to wait till the end of the presentation. You can go ahead and put those in the chat. We will likely wait till the end for to answer questions, but if you have questions along the way, just type them in as you have them so that you don't forget them, and then when the time comes, we will answer your questions. And all of our participants are muted and we can't see you, so feel free. You can get up, stand up, sit down, go for a walk, whatever you need to do to take care of yourselves, please, by all means, do. When I'm not leading a training, I love to go for a walk while listening to webinars and get a little fresh air. So, and if you have any technical assistance or technical issues, our training coordinator, Elaine, is the person to contact, and her contact info is here. And with that, I will introduce our speaker, Maddie M. Sandoval, who is a disability attorney here in San Diego. We are so thrilled to have Maddie. This is, as I mentioned before, this is a very highly specialized area of law, and we often have a really hard time finding lawyers who know this area of the law inside and out, and Maddie is really specialized not only in SSI, SSDI work, but specifically in helping people with PTSD successfully get SSI and SSDI, which, as those of you who are working with survivors, who are survivors yourselves, that is one of the main bases for disability among our client population. So I'm really looking forward to hearing from him. And with that, Maddie, I will let you take it from here. Thanks for being here.
Thank you very much, Jamie, and good afternoon to everybody. My name is Maddie Sandoval. I am a local San Diego-based attorney. I've been specializing in Social Security disability and SSI disability claims for, I'm in my 32nd year. So it's been for the entirety of my professional life. I came down to San Diego in 1979 to attend the University of San Diego, came down to play football actually. Went to law school there as well. And I'm often asked, how did you get into this type of work? And it's kind of a quaint story for those of you that are of my age, and I think there's probably none of you. But back in the old days, long before laptops and internet and anything, the employers in town would actually put up a job listing on what we call the job board, which was a cork board attached to the outside of the wall at the law library at USD. And after I'd taken the bar, I was entirely broke, looking for a job, and I saw a little 3x5 card for a local Social Security disability lawyer looking for a law clerk. It was full-time work and it paid okay. And I applied, and fortunately I got the job. After about a week of training, I was assigned a federal court appeal. And it was my job to write the brief to try to establish disability for someone that had been denied at the administrative level. at the Social Security Administration. I won. It was great. I was excited about it. And in learning the law from essentially the top down, the federal court level, I fell in love with it. I'm of the firm belief that there are three elements of society that the government should look after. One's the elderly, the second being children, and the third being the disabled. And my feet landed in the disabled category. And I've just had a great, great career representing Southern California's disabled, a very vulnerable population, and have made my entire life work serving that class. Like Jamie said, the purpose today is to kind of pull the curtain back and teach you how to do what I do, so that your clients, the claimants, will never get denied and will never need somebody like me going to bat for them in a court setting. We're going to go through a couple of primary areas today, and you could go ahead and go to the agenda, please. So we're going to talk about what happens after application. Well, first, how to apply, and then what happens after application, the various denials and appeals, and what's going on behind the scenes at the Social Security Administration. That's going to take about the first half of this, and then we're going to get into the meat, I would call the procedure the potatoes, which is the law, and how you actually prove a person's disabled, something that social workers and case managers are quite capable of doing at the very earliest parts of the case. And again, the hope being that you can qualify for these much needed SSI and Social Security disability benefits without ever needing a lawyer. So with that, we'll go to the application. There's three ways, okay, one back, if you will. Yeah, there are three ways to apply for disability benefits. Back in the dinosaur ages, the only real way to apply was to go to a local Social Security office. They're sprinkled throughout San Diego County, Imperial County, Moreno Valley, all the way up through, well, across the country, really. And there's an actual physical building called a Social Security District Office. In the old days, you'd go into that very crowded district office, something like the DMV, maybe not quite that crowded, take a number, wait till you're called and tell them you want to apply for benefits. Nowadays, then many years ago, they instituted a national telephone center. You have that number there. It's still the same number, 1-800-772-1213. And you can apply telephonically. Because they're national, there's oftentimes a pretty long hold. So not ideal, but you can certainly apply that way. Then, a decade and a half ago, Social Security, I don't know exactly when, they put up a website and you can apply online at ssa.gov. So that information is all given to you there on how to apply. The application is pretty thorough, not real easy. I anticipate you're probably going to need to help your survivors through this process. And the information you give there is pretty important. Number one, they ask you for all of your medical treating sources, hospitalizations, if any, and then a job history. The job history gets to be pretty important. We'll talk about that a little bit later when we get down to the hearing, the actual hearing and what happens there. So what happens after you apply? Well, the federal government contracts with a state agency or bureaucracy, and they do it in every state, that actually handles the back part of a disability application. It's assigned to an analyst in California, it's the Department of Social Services, and the sub-department is the Disability Evaluation Department. And there are state employees called disability analysts, and a claim is assigned to a disability analyst. It's their job to go out and get all the medical records. Sometimes people will have those and upload them, at the initial application, but if not, all you need is the information of your doctors and like I said, any other medical providers, including hospitals. The disability analyst then organizes it, and they have employees that we call state agency doctors, DDS doctors, the DDS being the state agency. And they are budgeted 8 minutes to read through an entire medical file on a person and make a recommended decision whether a person's disabled or not. Obviously, these aren't doctors that have ever examined a person or even talked to them. They just read medical records, check some boxes on a computer, and make a recommended decision. That decision's forwarded back to the Social Security Administration, and almost always, and that's what we're trying to avoid with this training, but almost always the claim's denied. And I say almost always, meaning high percentage. The claim's denied. A lot of people give up at that point, which is unfortunately, I think, part of the design of the system. They say, well, you know, I tried and I got denied. Guess I'm not disabled. What am I going to do now? Well, part of the denial letter specifies how you can appeal. There is an appeal called you could now switch to the next slide, please. The appeal is called the request for reconsideration. It's a one-page document. There's 3 lines to fill in why you think that you're disabled and that the decision was wrong. And you submit that, and the same procedure happens. It goes from the Social Security Administration back to the State Department Disability Analyst. And then in order to give the appearance that another doctor puts his eyes on these things, they'll farm the evidence to a second doctor, generally a couple cubicles down from the first doctor, who almost uniformly rubber stamps the first doctor's opinion, which results in a reconsideration denial, which is your second denial. We can go to the next. At that point, they've already denied you twice. A lot of people get so beaten up by all the appeals that they quit then too. But at that point, the next appeal is a request for hearing with a Social Security Administration Administrative Law Judge, ALJ, I'll refer to them as. The ALJs are trained. All they hear is disability appeals in a disability hearing. And some are good and some are bad. But in San Diego, we have 11 of them. And they cover both San Diego and Imperial County. Your client's file is then electronically transferred from the local district office to the Social Security Court. Now we're calling it the Office of Hearings and Operations, and that'll probably change. They've changed it 3 times in the last 10 years, but that's a Social Security Court, for lack of a bureaucratic term. You get in line, electronically in line, with all the appeals that have been filed before yours. Pretty long line. I think it's going to get longer after COVID, but it takes from that point to get an actual hearing somewhere in the neighborhood of about 9 months, maybe 6 to 9 months. Once it gets to the front of the line, it's assigned to a judge, and they just go 1 through 11 and back again. I'm often asked, how can we skip the line? Well, understanding that most everybody that is fighting for these benefits have gone without an income for a year or longer, they're very, very selective on what constitutes what they call dire need. And that would be a reason to skip the line. There are 3 areas that qualify for dire need. One is homelessness. The second one is lack of access to food. And the third one is lack of access to adequate medical care. We do, at my office, understanding I do about 250 of these cases a year, regularly submit dire need requests. About 25% of my clients are homeless, and on all of those, we'll submit a dire request. And most of the time they're granted. They know we're not just asking for everybody to skip the line. So with mine, that most of the time they're granted. But generally, you wait in line. It gets assigned to a judge. A judge, one of the judge's assistants will slot a claimant in for an administrative hearing. It's by law, they have to give you 72 days. In other words, it's scheduled 72 days out. And at that point, if your client hasn't secured an attorney, you're going to need one. It's an actual court hearing. It's an evidentiary procedure. There's a lot of law involved, and far too many people go to court without a lawyer thinking that they can do it on their own. And it just doesn't generally turn out well for them. At the hearing, which is for us down on B Street, it's 2 floors on the 500 block of B Street. You go into a hearing room, there'll be a judge. Some of them wear robes, some of them don't. Most of them wear robes, but some don't. It's supposed to be a non-adversarial proceeding, meaning I'm not fighting against another lawyer or a prosecutor for the government. It's just the judge and me and the claimant, or the judge and the claimant. The judge has an assistant that makes an audio recording of the hearing. And on almost all hearings, there'll be a vocational expert. That's the V and the E that you see on the slide. At some hearings, there'll also be a medical expert. Now, a medical expert is similar to the doctors that have already reviewed the cases for the state agency, but they're not constrained in terms of their review of the file, and they're there to help the judge decide whether a person is disabled or not. There aren't too many cases that have MEs, but some judges like them, some don't. The judge generally nowadays, the judges ask the questions of the claimant, and they almost always fall in the same general categories: education, work history, medical history, current medical treatment, why a person thinks they can't work, and how their impairment or disability impacts their daily life. The hearings are relatively short. They're average probably short of an hour, somewhere in the 45-minute to an hour range. And then the judge adjourns. They are instructed not to rule from the bench. And I'll explain to you why, and it'll probably make some sense. A lot of the people there are emotionally fragile, some of them even prone to violence. So they're not going to tell you, we're going to deny your claim, or that have drama on their hands far too often. Almost everybody there is financially desperate, if not destitute. And if they tell you we're going to grant your case, and it takes them, a month or 2 to get the written decision out, and they'd be getting calls every day. I'm about ready to get evicted. I'm on the streets. I got to get off the streets. Winter's coming, whatever. So on both sides of things, they're instructed not to tell you. Some of the judges will tip their hand, or I might get a feeling just from experience which way it's going to go. Maybe the medical expert testified favorably, or something the vocational expert said helped. And if so, I'll share it with the claimant, but oftentimes I won't know. I had 2 hearings this morning, and both of them, I don't know what the outcome is going to be. The vocational expert's job is to classify former work, if any, in terms of the exertional demands, how physically difficult it was, from a sit-down job up to a very heavy job, and in between, light, medium, heavy, very heavy, and also skills, if any, that they acquired having worked that job. And then the judge will ask them, the vocational expert, to consider a person of the claimant's age, educational, work experience, able to do A, B, C, and D. Can they go back to their old job? Is there any other work they can do? An attorney's allowed, and I guess a person without an attorney, to cross-examine the ME and the VE. And like I said, the whole thing wraps up in 45 minutes to an hour. Now, I like to tell the claimants, this is the first full and fair opportunity you'll be given to present your claim. I think that the system's pretty skewed against claimants prior to the hearing. But fortunately, in San Diego, we've got pretty good judges. I would say much better than in my 30 plus years of doing them here. We've got good judges. In the old days, the judges were mostly retired military. They were all attorneys, but they were retired military. In the application to be a federal ALJ, there was a extra 5 or 10 points given if you were retired military. And because we have so much retired military here in this county, and they were very conservative, and we had a pretty notoriously difficult bench down in San Diego. But we've got good judges now. I like most of them, and I appear in front of them over and over and over again. So let's assume a person is denied at the hearing level. The next. So there is a written appeal to the Appeals Council, which is outside of Washington, D.C. It's actually in Falls Church, Virginia. And they review the appeals for every denial. Well, for everybody that files an appeal following every ALJ denial. Because they hear appeals from the whole country, this is, again, a very lengthy process, somewhere in the neighborhood of 6 to 12 months. And you write to them, sometimes a brief, sometimes just on their form, why you think the judge was wrong. This is the final administrative appeal. So if you're denied there, and we can go to the next one, then you can sue the Social Security Administration in federal court. So the federal court, the lowest level of federal court is called the United States District Court. It's probably also the highest court in San Diego County, it is. Normally the trial court, they hear trials, drug busts, immigration issues, they're a trial court. But for us, they sit as an appellate court. And it's important that I say that because they're not retrying the case. They allow the attorney for the plaintiff, that used to be the claimant, to file a long written research paper, we call a brief, on why we thought the judge was wrong. And then because it's a lawsuit, Social Security has their attorneys. They're up in San Francisco. We call them regional counsel. Well, that's what they're called. And they file their brief. And then we have an opportunity to file a reply to their brief, submit it. You don't even appear in court. And then some months later, you get the decision of the federal court judge. Now, both at the Appeals Council and the district court, 3 things can happen. They can agree with the ALJ, affirming, essentially denying the claim. They can reverse the case, thinking the judge messed up so bad, the ALJ, that they'll find the person disabled and award benefits, and that rarely happens. Although I just got a reversal in federal court, I'm real proud of that. But what they generally do is say, yeah, we agree with you, plaintiff. The judge messed up. We're going to send it back to him and give him another shot at it and either fix it or award you benefits. That's called the remand. So we're shooting for a remand or a reversal, knowing that we're probably at best going to get a remand. There are very few lawyers that do federal court work in San Diego. I think there's only 2 of us. I love it. It's like I told you, when I first took a job out of law school, it was where I started and probably where I'll finish. When I retire, which I probably never will, I might stop doing hearings, but I'll continue to do federal court appeals. It's a lot of fun for me. If you lose there, you can keep it on the slide because I don't have time. You can further appeal in the United States Court of Appeals. That's the second highest law in the country, highest court in the country. They're divided by districts. The Court of Appeals, the United States Court of Appeals for California is the 9th Circuit. You'll hear oftentimes on the news how the rest of the country views our 9th Circuit Court of Appeals as being overly liberal and crazy and everything. Everybody thinks of California anyway. But it's not just California. It's most of the Western states, or a few of the Western states. I've had 4 cases there. I've probably done over 400 cases, 500 cases in district court. And those those are real fun. You sit in front of 3 judges, really lofty judges. That's the judges they pick the Supreme Court justices from. And you submit these briefs again, fatten them up a little bit, and they just fire questions at you. And it's unnerving, but fun in its own right. If by chance your issue is so unique that they think it's worth publicizing, then it goes into one of those books. I know we've all seen lawyers that advertise and they have a stack of, or a bookshelf of books behind them that all look identical. Well, and those books are what we call case law. Those are the decisions of the court relative to some disability issue. And I've had a couple of published decisions, kind of a real nice feather for a lawyer to get one of those sometime in their career. You can, because this is federal law and it's federal benefit law, potentially appeal into the United States Supreme Court. In my time, I know of maybe 3, but for sure 2 cases that the Supreme Court has granted cert, is what they call it when they'll look at one. I think certiorari is the real word, but they just call it cert, C-E-R-T. And if they grant cert, it's generally because there's an issue in front of them that basically is profoundly impactful to the entire class of disability applicants. So that's the entirety of an application to through the administration level and to the federal court level. And so I'm going to take about a 30-second break to take a drink of water. If you want to stand up and stretch your legs, now's a good time. And I'll start again with the law in about 30 seconds. Okay, if everyone's on board, we'll get into the law. So this is where we're really going to focus today, and the evidence that we use to prevail. I'll tell you something I tell every one of my clients the day they hire me, that proving a person's disabled is somewhat like building a house. The diagnosis, which we call impairment, but doctors call diagnosis, is basically just the medical name of what's wrong with a person and what they're being treated for, is never enough. A diagnosis is just the foundation of the house. And the reason is because there's people with every diagnosis that work. The only diagnosis in my career so far that's automatically qualified a person for disability was AIDS, because back in the early days of that horrific disease, it killed everybody. So if you had AIDS, you automatically qualified for disability. You never need a lawyer. Now, there are 2 areas that laws come from in the United States. One is statutory law. That's law that's passed by Congress. The other is case law. We just talked about case law. Those are the laws that are created from judges' decisions out of a court. That's why they call it case law. The laws that regulate, the federal laws that regulate Social Security disability claims are found in the Code of Federal Regulations, or the CFRs. In the CFRs, there is a chapter for almost every severe disabling impairment. Now, there are a lot of medical conditions that are significant and severe, hypertension being one of them, but they're generally asymptomatic. Diabetes is another one. It can result in some significant medical complications, but as can hypertension. Hypertension can lead to strokes, but until they do, they really aren't what we call a severe impairment. A severe impairment or a severe diagnosis is one that has more than a minimal impact on a person's ability to work. That's the exact definition out of the CFR. I'm gonna not necessarily touch on the physical listings because I anticipate that most of your claims are gonna fall in the mental arena. But the physical listings are vast, as are the mental, but the physical listings are vast. But the physical impairments give rise to physical symptoms. For example, if you have a bad back, you probably have pain, maybe weakness. Bad hip, the same. Carpal tunnel, you have pain, burning pain usually. Excuse me, weakness. Those would be the frame of the house that we talked about earlier. Excuse me, I'm gonna have another drink of water so I don't cough. So again, the symptoms would be like the frame of the house. Now, a diagnosis, as I said, is never enough because there are people with every diagnosis at work. Symptoms are the same. Symptoms are never enough because there are people with every symptom that work. What really defines whether a person is disabled or not are what are work-related limitations. Every job, from my job, which is primarily a sit-down job, to the guys that I can hear working out in the street outside of my office with a shovel and jackhammers. Every job has an 8-hour combination of sitting, standing, bending, stooping, lifting, handling, fingering. My job, much easier than theirs, but we all have an 8-hour combination of those. And how a person's impairment or diagnosis results in work-related limitations is really what establishes or defines whether they're disabled or not. The more limited they are, they can't work. A person that can't sit for more than an hour or two a day, can't stand for more than an hour a day, obviously can't work 8 hours. And we'll get into the mental limitations as we move along. But the team, well, by the time you get to court, the team, the way I explain it to my clients is there's 3 people on the team. There's you, me, and your doctor. Obviously, if it's a disability claim, everything is essentially medical. All the evidence is pretty much medical. And so it's medical evidence that we're trying to use to present to a judge as to why a person's disabled. And so I tell people that your testimony is the least important part of this. If it came down to what a person said they could or couldn't do, everybody that applied would get benefits and there wouldn't be judges, there wouldn't be lawyers, and frankly, I think the system would be broke. But it has to come from doctors, and we'll get to that in just a minute. So back to the listings. 12.00 is the listing for mental impairments. So if we can switch that, please. Okay, all right, well, I just said that, so keep going. So how are they arranged and what do they require? We can go to the next page. So again, the 12.00 listings, and then we're gonna go through briefly the different sub listings under 12.00. And then we'll spend a little bit more time on the one that I think is gonna mostly relate to your clients, which is, as Jamie said, PTSD, which falls under 1206, but we'll go back to that. So the neurocognitive disorders, traumatic brain injury, that's the one I see most there. I see a lot of that with, unfortunately, people coming back from war zones, people who got in car accidents, any kind of head injury, NFL players. I had one NFL player that we won under neurocognitive disorders. 1203, schizophrenia spectrum and other psychotic disorders. My office, where I'm sitting now, is right up by Balboa Park. And a lot of homeless folks in and around my area up here. And rarely does a day pass that I don't see somebody on the corner yelling or talking to somebody that's not there. Those are psychotic disorders, generally psychosis. Thoughts fall under 2 categories: auditory and visual hallucinations. Visual hallucinations are people that see things that aren't there. Auditory are people that hear things that aren't there. And a very serious and sad disease is psychosis. Sometimes it's drug related or drug driven. Oftentimes it's an organic psychotic disorder. And schizophrenia is the umbrella over psychosis. So that's 1203. You'll probably see some interplay between PTSD and depressive disorders. That's 1204. That also includes bipolar disorders. That's a pretty big one. Most people that I see have some measure of a depressive disorder. If you take somebody's work away from them, generally they have some measure of reactive depression. Grief, another one. There's a multitude of them, but 1204 depressive disorders. 1205 intellectual disorders. Those are used to be called mental retardation. Now they've gotten PC and with the times and remove that pejorative term, and now they call them intellectual disorders. 1206, we'll get back to it, but that's anxiety and obsessive compulsive disorders. Post-traumatic stress disorder is certainly one of those. We'll cover that in a little more detail in a minute. Somatic symptoms and related disorders. Don't see a lot of that, but you do see it. Those are people that think they're sick and they're not. 1208, personality and impulse control disorders. I see quite a bit of that. People that have spent a lot of time in prison have PTSD and oftentimes personality disorders as well. You have kids that parents were helicopter parents squared. I get that, with some of my child's cases, and parents that want their kids to be sick develop a personality disorder. Autism, that's 1210, and then neurodevelopmental disorders. That too normally comes with children, 1211. Autism as well, that's usually picked up, and people usually get on SSI benefits prior to reaching adult age. So the ones I see most often are certainly 1204, 1206, some 1203, and then even less, but oftentimes traumatic brain injuries at 1202. So let's turn our focus to 1206, anxiety-related disorders. I didn't give you this page, but I'm going to go through it just orally, and then I'll make this available to Jamie, and that you could disseminate this along with the addresses of the local district offices. So anxiety-related disorders are, okay, let me stop for just a minute. In order to qualify for benefits by meeting one of these listings, you have to meet the A and the B criteria. Now the A criteria, excuse me, I have allergies with this Santa Ana, but the A criteria essentially goes to what do you have to establish to prove that you have the disorder. And so for anxiety-related disorder, they have a number of criteria for that impairment. Generalized persistent anxiety accompanied by three of the following: motor tension, atomic hyperactivity. Here's one: the apprehensive expectation, vigilance, and scanning, or a persistent, excuse me, a persistent irrational fear of a specific object or situation. Sounds pretty similar to PTSD. Recurrent severe panic attacks. That sounds like probably part of the symptom cluster you're going to see a lot of. Recurrent obsessions or compulsions, again. And then this one is very much on point with PTSD, and that's recurrent and intrusive recollections of a traumatic experience, which are a source of marked distress. So again, my bad, I should have gotten those to you, but I just realized I should cover those on the 1206s. But that's only halfway there. It's not even halfway there. That just proves a person has an impairment. Again, thinking back to the analogy of the house, we then have to turn to what's the functional impact of the disorder on a person's life. So if we can switch the slide. These are the B criteria. And this is really where a case is made or not, is the assessment of functioning. How does a person's impairment impact them in their functioning? If you have a bad back, how long can you sit? Again, going to the mental impairments, there are 4 areas on the B criteria. The ability to understand, remember, or apply information, the ability to interact with others, the ability to concentrate, persist, and maintain pace, and the ability to adapt and manage oneself. In order to satisfy the B criteria, in other words, in order to prove that you met a listing, there has to be a marked limitation in 2 of those 4, or an extreme limitation in 1. It's pretty tough to meet the listings. You know, I've sometimes been asked, why don't we just have the doctor ask about the listings? Well, understanding that in your case, you're going to be trying to convince a disability analyst and a state agency reviewing doctor with 8 minutes to spare that your client's disabled. And these listings are so specific that it's my belief those reviewers, particularly the reviewing doctors, don't think a doctor on the outside really knows enough about it to really be able to rate a person in those categories. So they don't usually look favorably on those specific criteria and the doctor's opinion on them, because again, they don't know how much the doctor knows on how to rate them. So many years ago, the Social Security Administration published a form that I think in some ways they're not happy sticking around with guys like me. But if we can go to the mental residual functional capacity assessment slide. So these are the ratings, and they're going to apply. They apply both to the B criteria, and they're also going to apply to the form that we're going to go over in just a minute. And so none is absent or minimal limitations, mild, slight limitations, moderate, more than slight, but the individual can function in those areas. Marked. Remember, you have to meet 2 out of 4 as marked. There are serious limitations. There is substantial loss in the ability that you can function satisfactorily, or in the ability to effectively function. And then extreme, there's no useful ability to function. So if we can go to the next page and we'll start taking a look at the form. Okay, the summary conclusions, I'm not going to go over. That's basically just how to educate a doctor or psychologist, also a doctor, in what they want in terms of the ratings. So we don't need to read through that necessarily. I'm much more interested in the next page. Oh, okay. Did we not? I guess we don't have the mental residual functional capacity assessment. So let me let me go through it briefly, because I don't think and I'll be happy to go to supply you with this, but this is a category breakdown, and there are a couple of real important ones, because this is really where you're going to make the case or not with your client and your client's doctor at the initial application. And so the form contains 20 specific questions, but the ones that really I utilize the most, and again, they have boxes under those 5 different ratings. A couple of the big ones: the ability to maintain attention and concentration for extended periods, the ability to perform activities within a schedule, maintain regular attendance, and be punctual within customary tolerances. Those are people that would call in sick or miss work. Oh, there we go. Okay, good. Okay, so I'm down to number 6 and 7. Oh, great, perfect. Okay, I just read 6 and I read 7. Now, again, if you think about it, there's people that would have what we call intrusive thoughts. You're probably more familiar with that than I am, because I'm guessing all your PTSD survivors have intrusive thoughts, but that's somebody that would decompensate at work and either need to take a break or go home. Or maybe had horrible nightmares the night before, never slept, and called in sick the next day. So that would fall under number 7. Number 8, the ability to sustain an ordinary work routine without special supervision. If we can change to the next page.
I only have the one page.
Okay, there's a couple on the last page, and it's fine because I'll just read them, and we'll make sure we get these all to everybody. But the one that is very similar to a couple that I just read, but it's the ability to complete a normal workday and work week without interruptions from psychologically based symptoms, and to perform at a consistent pace without an unreasonable number and length of rest periods. Again, you can see how that would translate to your survivors, somebody that would just lose focus on whatever they're doing. Be off task is what we call it in vocational parlance, be off task because they were ruminating or had an intrusive thought. Ability to respond appropriately to changes in a work setting, another one. But that form is the form that I send to every doctor for every one of my claimants that has a mental impairment. Now, the government is supposed to give the highest weight to a treating doctor. Doesn't always happen that way. Even the ALJs sometimes don't. Even the federal judges sometimes don't. But if a treating doctor, particularly a treating specialist, a psychiatrist or psychologist, and a person with a mental impairment, fills out that form, writes a couple notes why they rated the person where they have, then hopefully you win it at the initial application stage, but it certainly gives them a better chance of winning when we go in front of a judge. And if we're denied there, it gives me a much better chance of winning if I take the case up into federal court. So that's pretty much all that we were going to cover in terms of training. You build your case with medical evidence. The best medical evidence is opinion evidence, meaning this form from a treating source. So in order to give your client, the survivor, the best chances of succeeding, you want to get this form out to a treating doctor, and sometimes shortly after they've applied, get that into their file so that the reviewing doctor gets a chance to look at it. And that's in terms of the training, all that I was going to cover today, but I'm happy to answer any questions that any of you may have.
Maddie, thank you so much for that informative training. If anybody has any questions, you can type them into the Q&A chat box on your screen, and our senior staff attorney, Nicholas Moore, will be moderating our Q&A.
Maddie, I've got a question for you. In terms of waiting, I understand that like a medical doctor's evaluation might carry more weight than perhaps a social worker, but to what extent does frequency of interaction increase the weight when talking about a person with a mental health disorder?
That's a great question. And I totally agree with you that if I were a judge, and let's say it was a physical impairment, I'd look to see if there's any physical therapy notes, because a physical therapist actually tests and rates a person on how much weight they can lift, what their range of motion is. But unfortunately, and social workers the same. Social workers are in weekly, if not more often, contact with a person, but the weight is codified in the code of, in the CFRs, the Code of Federal Regulations. So the weight is, and it says a specialist, a general practitioner, a primary care doctor, family doctor, then an examining doctor, then a reviewing doctor. And right now, physician's assistants are taking over so much of primary care. They're even below those. So if I have, what I think would help, because some doctors and even some doctors you may work with might be unwilling to take the time and energy, or say, I don't know all this stuff. But if a social worker who could convince a doctor, I'll fill it out if you co-sign it with me, because I do know what the answers to all these questions are, the answers, the ratings in all these categories. And oftentimes I get that. I work with Imperial County Mental Health. I have an office in El Centro, and that's what I do out there, because They have such good interaction with the doctors trust them. And so they'll just co-sign it. And if the doctor signs it, the weight's gold.
Okay, well, that's great to know. I have another question. In terms of, the substantial loss of ability to function, are there some examples that you would expect to see in a PTSD case?
Well, there is, the categories I read are really the standards. So if with the people I see with PTSD, and I haven't ever, I don't think, represented a survivor of the type that you help at Free to Thrive, but I get a lot of veterans, a ton of veterans, and people that have had childhood traumas, sexual, physical, otherwise. I get those a lot. Sometimes spousal abuse type situations. I get those a lot with PTSD, and it's the symptom cluster is similar that I see anyway with PTSD. Intrusive thoughts are huge. Feelings of fear, the paranoia type feelings, they're huge. But it's, again, not just the symptoms, but their impact on work functioning. That's really where the case is made. That's why I use the whole analogy of the house, because it's the impact of the symptoms on a person's ability to work. I mean, some people, for example, let's say a survivor, a female survivor couldn't work with the male supervisor. Well, that's a limitation. Anything that would limit, that would erode their ability to function in a workplace is useful.
Okay. Great information. I've got a question from Michael. He asks, since the evaluation period can be a few years before SSI or SSDI is approved, is there a limitation on how far back they can approve on back pay?
Great question. So for SSI, they'll go back to date of application. For regular Social Security, they'll go back 1 year prior to the application, or if the disability's later than that. In other words, if it motors through the system quicker. But no, I just got a case where I got 8 years back pay because they'd applied 8 years ago and just kept getting batted back and forth between the appeals council. And so you'll get them, my federal court cases generally have 4 or 5 years back pay.
Okay. We have a question in the chat from Julia, which is geared, I guess, more towards Free to Thrive staff, asking if our clients are getting the mental health care that they need. Arguably, no, simply because most of our clients are on Medi-Cal, and getting mental health care through Medi-Cal is an extraordinary challenge, especially getting consistent health care through Medi-Cal. So, do they have access to, are they getting the mental health care they need? It's hard to say that they are. And it's more likely that they're not. And this is definitely an area of need that we have identified with a lot of survivors.
Nick, can I speak to that for just a second?
Sure.
Since Obamacare granted Medicaid, which is Medi-Cal here, to so many more people, doctors have signed on to it. And so public health is just kind of a trailer on what I do. And there's way more doctors than there was 5 years ago taking Medi-Cal now. So I don't know how to advise you, except to say there's a lot more opportunities than there used to be.
Sure. And I will also say a lot of the survivors we work with are through some great community partner programs that do have wraparound mental health services as part of their programs. And a couple that come to mind, specifically would be North County Lifeline and Generate Hope, and Alabaster Jar Project are the three that sort of immediately come to mind that do offer pretty consistent and positive mental health services.
Yeah, and I would just add to that, I think the challenge, Maddie, is finding people with an expertise, not just in working with trauma survivors, but working with human trafficking survivors, because we found even therapists who are really specialized in the DV space, serving domestic violence survivors, aren't always the right fit for our clients. Sometimes they are, but sometimes they're not, because our clients' trauma is really complex trauma, and there's PTSD is severe PTSD, and there's really incredible treatments and therapy options for people with PTSD, but there's just such a limitation in terms of therapists who are actually trained in the specific modalities that are best suited for this population. So it's certainly a challenge. And to whomever asked the question, if you have any resources for our clients, we would definitely be open to them.
Okay.
But as Nick said, we are very grateful that at least we have a number of great partner organizations that do provide those services.
Yeah. Michael asked another question. How can a client afford to pay for an attorney's service?
Yeah, that's a great one. And I probably should have, I was going to say that at the end, but this is a good time for it. Thanks, Michael. So we talked about back pay. The government will pay you for the fight. And the way that I get paid is you get the months that you fought times whatever the monthly amount is. For SSI, it's just under $1,100. My fee is 25% of the back pay, only if they win. If they don't win, they don't get any fee at all. I don't get any fee at all. There's no charge. And then they get on monthly benefits and they don't pay out of those. And it caps at $6,000. So it's 25% of the back pay with a max of $6,000. So there's no money up front. If anybody ever talks to a lawyer that says, that tries to charge them any money, that does this, they should report them to Social Security.
And just for those who are not familiar, Free to Thrive does not charge clients for our services as well. So you're entirely pro bono. Okay, I think that's it for the questions. Thank you, Maddie, so much for your
I just
time
have
and your
a closing
expertise,
thought, if I
and your
can't
willingness
share.
to work with us.
I'm sorry. I'm sorry, Nick. I didn't mean to interrupt.
It's okay. I think I am having some internet difficulty.
Go ahead, Maddie.
So I just wanted to say this, and it's I don't want to be sanctimonious at all, but I've done over 8,500 disability claims in my 30 plus years of doing this. And Social Security is a safety net for the country. I'm grateful that we have it. We all should be. There's a decent percentage of clients that I've represented that aren't disabled. I lost a lot of cases and will probably lose a lot more. There's cases that I represent that they're not disabled even by my estimation, but I'm not going to drop them. I've taken it in good faith and I'll see it through. Work feeds us in a lot of ways, not just financial remuneration, but it enhances our self-worth. It gives us a sense of purpose. Social Security disability and SSI disability really is the last thing that someone should be looking at in order to help anybody. And it's there, and your service is to be greatly applauded. What you do at Free to Thrive, I've just gotten to know you, and it's an amazing organization. And I like what I do. I've had a great career thus far, still going, and it's been my pleasure and my honor to talk to you all today.
Well, thank you so much, Maddie. We are so grateful to have your expertise here to educate all of us. And for our audience, this started just as we were going to do this as an internal Free to Thrive training because we wanted this education, and we were fortunate to connect with Maddie, and he offered to train us. And I said, there's no reason why it should be limited to Free to Thrive staff. There's so many other people that could benefit from this education, and Maddie was kind enough to let us open it up to all of you. So thank you for attending. Thank you, Maddie, for taking the time to prepare and present this presentation. We are very grateful and look forward to hopefully collaborating with you in the future.
And if any of you have any questions, need direction, free advice. You got my contact information. I'm real good about returning phone calls. You can learn more than I covered today if you want to go onto my website, and how to contact me. Any caseworkers, social workers, case managers, attorneys, long before they get to the hearing. If you need any guidance or assistance, I'm here.
That is a very generous offer. And I know that for a fact, Free to Thrive will be taking you up on that offer. So thank you.
My pleasure.
That's incredibly kind of you. Thank you everybody for attending and for supporting survivors in this way, and have a great, happy holiday season. Take care.
Okay, thank you. Bye.
Bye, everybody.